So now I would like to provide some preliminary information also on the intellectual property policy of IMI. It's really important when you would like to understand the IP policy applicable in IMI project to always keep in mind the IMI objective, because it has been clearly set up from the beginning that this IP policy has been designed considering the global IMI objective. And first, of course, the objective is to promote the knowledge creation, but it's also important to ensure disclosure and exploitation of this knowledge generated within IMI project. Besides these two general objectives, we have also to consider the interest of all the participants, FPI company and participants eligible to receive IMI funding. It implies that during the collaboration, it will be important to ensure a fair allocation of right, but also to reward the innovation. This is also a way to provide interest in the participation in IMI project. This IMI policy, in order to consider all these objectives, has set up a general framework. These are minimal conditions. Consequently, there are some scope of flexibility, and it will be up to each consortium to clearly use this flexibility considering the project objective, but also the interest of each participant in the consortium. This will have to be translated in the project agreement. This project agreement is the agreement which will be signed between the participants of an IMI project. The IMI office is not part of this consortium. IMI office will only sign the grant agreement with the consortium. So it implies that discussion will have to take place between the consortium before discussing the expression of interest, but also when submitting the full project proposal in collaboration with the FPI company, and during the negotiation if the proposal has been successful. These issues are really important, and it's very important for all of you, if you intend to participate in an IMI project, to really understand the scope and the objective of this IP policy. This will avoid misunderstanding in the future. To that end, in order to help you, in order to avoid any such misunderstanding, we have prepared a second IP guidance note. If you have been already on the IMI website, you have probably seen an IP clarification note, because some of the terms were not sufficiently clear for all the participants. But it appears that following the negotiation of the first call project, some of the issues were still remaining. So that's the reason why it has been decided within the IP working group, composed of several representatives from the European Commission, from the FPI company, but also from members of the state representatives, to discuss how to draft this IP guidance note. This IP guidance note aims to explain you this flexibility I've just explained and how to handle this flexibility, but also to already provide to the applicant and the participant some way to solve the issue or to explain the different options provided in this IP policy. So as I've just explained, you have already available on the website several documents, and will be soon available this IP guidance note. This IP guidance note is under finalization. At the beginning, we aim to publish it today, but you may understand that it implies a lot of discussion, and this will be published next week with the official launch of the call. So just to explain you also how it works within this IP working group composed of several representatives, the objective is clearly to exchange views on this IP policy, but also to receive concrete feedback from the ongoing project. Because at the beginning, most of the discussion were theoretical discussion, and now we would like also to see how these theoretical discussions were implemented during the negotiation and how this IP policy has been implemented in the project agreement. So that's the reason why we have invited different ongoing projects to explain us how they have handled the IP negotiation and what are the solutions they have found during the negotiation. So, back to more technical issues. Concerning the IP policy, it's important to have in mind several key definitions. The third important definition relates to the background, the foreground, and the sideground. If I would like to simplify with a pen, I'm interested in participating in an IMI project, and I have this wonderful information, knowledge in my hand, and I would like to use this because of my participation. So I will identify this because I will consider this pen as really useful to achieve the objective of the project. So, and I will identify in the project agreement, and consequently, I will have to provide some access right on my pen to the other participant of the consortium. So I've developed this pen before my entrance into the project, but because of my participation into the project and because I consider this pen as useful for the project, it will be nominated as background, and I will provide on this background some access right. I will have some right and obligation. So now I'm participating to a project. I'm with you in a project, and we are developing. The objective of the project is to develop a pen, another one, but I have to use my previous technology. So we are developing this pen within the project, and this is clearly in line with the objective of the project. So this pen will be considered as foreground. But let's imagine another situation. I have also developed this pen during the implementation of the project, but outside the scope of the project objective. Because of course, you will participate to IMI project, but you already participate to many other collaboration with other entities. So it might happen that you develop some technology, some knowledge, some know-how in parallel to this project and outside the objective of the IMI project. So consequently, this pen now will be considered as sideground. So it's really important to determine when a knowledge, when a know has been developed and in which context. So consequently, in order to clearly set up the distinction between foreground and sideground, it's also very important to understand the project objective, because it's only if you understand the project objective that you will be able to determine if my pen will be considered as a foreground or as a sideground. So you will also perhaps mention, but what happened to any other node developed in parallel, completely in another scientific area? This hasn't been mentioned in IMI, but this may be clearly identified in your project agreement, that anything that has been developed in parallel to the project, outside of the project objective, will be considered as sideground, and this will have an impact on your right and obligation. If we have a look on this scheme, it's try to summarize the situation. So you have developed some background, you will put this background available to the project, and you will have to probably grant some access right for different purposes, for implementing the project, for research purposes, or for direct exploitation under terms to be determined in your project agreement in accordance with the IP policy. But you will see you have a box. The project is the description of the box, and everything that has been developed within this box will be considered as foreground. And all the other things developed outside the box, but during the same time of the implementation of the project, will be considered as sideground. So that's really important, because this is the startup of the negotiation, to understand and to clearly determine what will be considered as background, as foreground, as sideground. So another definition, a very important definition, research use. This definition has been specifically tailored to IMI objective. And it's really important to understand that research use go beyond the acceptance of the term of purely academic research. That's really important, and it created a lot of confusion during the first call, because you are used to participate in community program, you are used to see this term use, and generally, when you see this term use, you are automatically thinking about academic research. But in such a case, in IMI project, it goes beyond this term, because it may include the application of foreground for research purposes, for the possible development of technology, tool, pharmaceutical product by for-profit organization. So that's really important to clearly understand, because it will have an impact on the financial term you will define in your project agreement within the consortium. Another important definition is direct exploitation. Here we are clearly talking about commercialization. It may be direct commercialization, indirect commercialization through licensing agreement. Here we are clearly faced to the commercialization approach. So it's important to understand these two concepts. And at the end, the dissemination, that is to say, the disclosure of information by any means. It may be publication, it may be journals, it may be participation in conferences, it may be website. So, concerning the background, let's take my pen. I would like to participate to a project. I've developed this pen before my participation to an IMI project. I was the owner. I participate to the project. I will still be the owner of my background. It will not impact on the ownership. The participation will not impact on the ownership. But because I will participate in the project, I will have also to provide some accessory for certain purposes, and notably for completing the project or for research use purposes. But because I'm the owner, I will be free to license or to transfer ownership of this background. But of course, I will have also to pass on my obligation to grant some accessory, because if I would like to transfer ownership of my pen, I have it identified as a background. It's not because I will transfer this ownership to a third party that all my obligation to grant access right will disappear. So it's really important also to transfer the right and obligation you will have because of your participation in an IMI project. It will be also possible before participating to an IMI project to already mention any legal restriction you may have on this background, because it might happen that you have developed this pen, you need this pen for carrying out the project, but you have already granted an exclusive license for certain purposes to a third party. So it's important to inform the other participant of this kind of legal restriction. And as mentioned at the beginning, it's really important to identify the background, because only the background identified will be considered as background. And only on this identified background you will have right and obligation considering your participation in an IMI project. So concerning the foreground, let's take this other pen. I have developed this new pen in the course of the project. So because I've developed this pen in a project, I will be the owner, but it might happen that we have jointly developed this pen. So we will have to agree on the joint ownership modalities. But we may also consider that only you will be the owner, because only you will be entitled to really exploit the pen. But it implies that we have to define compensation. We may also consider that we still be the joint owner, but once you exploit the pen, I will be rewarded for that. So that's really important when you negotiate, when you are discussing joint ownership, to also identify possible modalities, to already think about possible joint ownership and consequently how you will handle this joint ownership.